welcome to this workshop on greenwashing and climate change from legal perspectives. I will just, Hannah, maybe again reintroduce the center and the program within which this workshop is organized. Apology.
Yeah, let me welcome all of you, our speakers and our audiences in person and online. And thank you for being here with us. And we hope the workshop will be an inspiration for you. We are welcoming you on behalf of the Czech Academy of Sciences in Prague, where this workshop takes place. I will also begin with a few words about our center. The Center for Climate Law and Sustainability Studies is the first research unit specialized in climate law in the Czech Republic. We were launched in 2020, and since then we have been working hard to establish and develop the new field of climate law in the Czech Republic and to explore all the challenges that climate change poses to law at all levels, nationally and internationally. And also an information about this project. This workshop is organized as part of the project Climate Change Law in Europe that is supported by the Research Foundation Flanders, FWO, and which is led by the Environmental Law Unit of the Hasselt University that is today represented by our last speaker, Matteo Fermeglia. The aim of the project is to develop a collaborative network of academic centers in the field of climate law in Europe. And before we start our greenwashing topic, let me mention a few technical issues. First, this event is being recorded. We plan to use the recordings to be published at our YouTube channel upon the consent of our speakers. We believe that this publication will help to better disseminate the findings of the project. But if any of the speakers does not agree, please tell us, and we will not cover your presentation in the recording published. The discussions will not be published. And finally, the last remark, the views expressed by the speakers represent their individual views and not the views of the Institute of State and Law or the Czech Academy of Sciences. So hopefully I covered everything needed for the organization. I wish you enjoy the workshop. And now, Monika, please, the floor is yours for follow-on.
Thank you very much, Hannah. So I'm glad to welcome Elias Van Gool, I hope I pronounced it correctly, who will give us the keynote speech and who will basically open the discussion about greenwashing / climate washing. I will just repeat and encourage people who are online. If you have questions, please write them in the chat. We have reserved some time for discussion because we would like to have the discussion, even though the time is limited. So now, Elias, I will just introduce you. So Elias Van Gool is a PhD researcher at the KU Leuven and Université de Lille. And his research focuses on the intersection of EU economic and environmental law, in particular sustainable consumer law, and the broader relationship between individuals, communities, and the transition to more sustainable development. He holds LLM in environmental law and policy from Stanford Law School and a research master of laws from KU Leuven. And prior to starting his PhD and his teaching activities, he also worked at Baker and McKenzie. So Elias, the screen is yours.
Okay, thank you. Thank you for, first of all, to Hanna Müllerova, Rita Simon, Monika Feigerlová for offering me the honor to open this workshop on an important topic. And I regret not being able to be present in beautiful Prague. It's a marvelous city, but technology allows us to, notwithstanding agenda complications, to participate and collaborate across borders. So that's the benefit of the present day and age, of course. So my introductory talk let me see. I was asked to give an introductory presentation. So I first of all would like to briefly outline the broad scope of the issue of climate-related greenwashing and its importance to what we're doing today to examine it separately from greenwashing. And then I would want to dive into the toolbox of potential regulatory approaches to dealing with this complex issue, and to provide some food for thought for following discussions and presentations. I would briefly want to provide some relevant insights from behavioral science, and then outline some of the main features of the technical complexity inherent to climate mitigation, climate adaptation. That is one of the main reasons why, in my opinion, climate-related greenwashing is such a prominent and growing issue. And then often discussed last among lawyers, but especially here, definitely not the least important, the dimension of enforcement. And then I will wrap things up in a conclusion. So first of all, regarding the concept of climate washing, I propose the definition which you see here. I'll put voila. This is just based on the definition that the Commission provided in the Unfair Commercial Practices guidance already a time ago on greenwashing. I think that's a more broader definition, and for example, what you find in the Taxonomy Regulation, the definition there of greenwashing, and I adapted it just to the climate change context. But by adopting this broad definition, you avoid, I believe, the risk of under-conceptualizing the issue and perhaps also consequentially under-regulating it. As this definition allows that it's not only possible climate washing, if I would call it like that, issues related to climate change mitigation, which are of course most prominent, and current cases are all related to the impact of products and services or organizations on climate change mitigation, to what extent they positively or negatively contribute. But in term also, that's already present in the financial context, but also for more traditional products and services, climate change adaptation capacity will also be relevant, especially from a consumer protection or generally a customer protection perspective. And then that's more looking ahead, and it's less likely, but nevertheless also the loss and damage dimension can, over time, it's intrinsically related to climate change, be part of especially financial products, but also once, especially in terms of the consequences of climate change, global inequities become clearer. Certain producers, service providers might want to differentiate their offering based on, for example, to what extent certain profits are invested in loss and damage compensation, or whether the supply chain tries to actively contributes to restoration or reconfiguration of economies that have been already disproportionately affected. So that's very much looking ahead. It's true that it's now all about mitigation, and I think over time adaptation will become more prominent. The loss and damage is more an afterthought that might pop up in the future. And as many cases which are already out there show, it's not only restricted to products in the widest sense, also services like transportation services, and more also market communications about the relationship to climate change of organizations overall, often regarding brands of companies in sectors like food, fashion, that's already very prominent. And then it's very broad that it not only relates to current or past, that's even less likely, but current relationships to climate change, but especially future commitments about future relationships. And I will further in the presentation come back to that issue, because pledges about emission reductions are particularly prone to potential climate washing or allegations thereof. And then finally, the energy sector, specifically oil and gas, is obviously crucially important, and the most pronounced cases of potential climate washing are often specific to that sector. But since it's such a pervasive issue and a challenge for the entire society and economy, almost all sectors conceivably can have relevant climate washing discussions, whether a certain market communication is deceiving or not. And then, although I myself, as mentioned in the introduction, have partially a background in consumer law, often the focus is on the B2C relationship, because probably the legal rules there, protective rules, are the strongest. Also because there is more asymmetry, the consumer is most vulnerable. But I think there are relevant rules for all these other type of relationships, and especially when you look to broader civil law. And because of the complexity of climate change, I believe this asymmetry and the possibility to be misled is, for example, in the B2B context, equally present. So I'm very happy to see that also this workshop has a very broad conception, and that it's not limited to just sustainable consumer law, because it's definitely a much broader issue. And then a question on why separating it from greenwashing, which is another way of asking why is it relevant to separately study it. Yeah, definitely, perhaps more than other ecological aspects that are dealt with under the greenwashing umbrella, climate change in terms of mitigation, it has a very direct impact on humans, and especially when we talk about adaptation of a product or a service, it already directly affects you as a customer. Then, as mentioned, the technicality, the complexity of relevant soft law and regulation automatically sort of make it its own domain worthy of separate study. And then from a traditional liberal view, there is more and more data out there that it's salient to the average customer, especially the average consumer as well. There is also research that shows that the behavioral gap between feeling responsible in terms of consumption choices for climate change and acting upon it, that this gap is closing. There is a lot of data out there, especially regarding greenwashing in general, but nevertheless, that there is quite some climate washing. So that's definitely worth further examining and perhaps strengthening the regulatory framework. And then finally, the most overriding reason is obviously that we're in a climate emergency, and consumption choices are actually crucial. Just when we focus on B2C, household consumption choices directly and indirectly would amount to 2/3 of global greenhouse gas emissions, according to this study. So it's definitely a huge topic and challenge. If we then dive into the toolbox, just giving a broad overview of potential regulatory approaches. First of all, as from the outset, the sort of general idea of where we are and how we approach it in our European legal system, there Gilles and others provided conceptual review of sustainable consumption, literature and policy approaches. And they distinguish between a reformist approach, which is the academic and political orthodoxy of firms pursuing green eco-innovation, consumers buying more sustainable products. And that's often contrasted with a more revolutionary approach, emphasizing degrowth, frugality, sufficiency, localism. And they find this dichotomy quite stifling, and they also claim that it often leads to limited factual or policy-wise outcomes, and they propose more a middle ground of reconfiguration where the focus is on transitions in socio-technical systems and daily life practices, and that seek a more achievable transformation, but the transformation nevertheless, which distinguishes it from the reformist approach. And I think the current legal framework is very much in the reformist realm, but more and more, especially with the new proposed B2C regulations, green claims, empowering consumers, there is a shift that might be more qualified as reconfiguration, where it's no longer pushing at the margins, but trying to achieve a real transformation that the market dynamics are fundamentally shifted. And then when discussing possible regulatory approaches, I would like to first of all emphasize that all ex-ante regulations in general, which relate to climate mitigation and adaptation, indirectly are relevant to combating climate washing, simply because they limit the space in which the remaining climate washing discussions take place, to the extent that binding regulations, not only more general climate policies, but also, for example, the new eco-design, sustainable products regulations, or the economy regulations that require that products have a more limited, in the production phase, greenhouse gas emissions impact. They also result in the fact that there is fewer space for remaining claims that might be potentially misleading or not. And then also ex ante, there are typical EU regulations that pursue transparency. Obviously, in the financial realm, there are a lot of relevant regulations. I only mentioned taxonomy here as the most obvious, but also the more recent corporate transparency relating to sustainable development regulations, even ARUS to some extent, when you consider potential climate washing by authorities and the fact that some public authorities under ARUS are actually private companies, is also a regulatory approach that pursues more transparency. And obviously, especially in the B2C context, with consumer rights directive disclosures that are now expanded by the Empowering Consumers proposal, the green claims proposal, all pursue more transparency that ultimately sort of reduces the risk of potential climate washing. And then you have the discussion to what extent all these ex-ante approaches should be sectoral based or more horizontal. And then the core of regulating climate washing is obviously ex post, when there is a claim of potential deception, misleading statements. In this category, a further distinction can be made. The most far-reaching approach are bans, for example, the French ban on fossil fuel advertisements. But there you always have discussions about scope. For example, under the French ban, perhaps fortunately, energy companies, even more oil and gas oriented companies, can still advertise regarding their renewable energy activities, if they do so not in a misleading way. And it also touches upon the fundamental observation that we actually need these market communications to create incentives on the markets that push towards more sustainable production and consumption activities. So the approach of bans, I agree with the analogy between tobacco advertisements and fossil fuel advertisements, but for the more broader issue of climate washing, it's only a very partial, limited solution. And although there's a lot of campaigning about ban fossil fuel advertisements, I believe it's then only like more an issue in the margin. And the more fundamental, far-reaching solutions are more general prohibitions on misleading statements. Obviously, in B2C, unfair commercial practices, general clauses on misleading actions and omissions are very relevant, but also general civil law, especially rules on contractual validity relating to fraud and or discussions on contractual conformity, sales law, and other contractual regimes. These are all grounds that can be invoked, especially for a private claim by a possible customer. But also in some countries more than others, there are B2B unfair trading practices rules, which are at the EU level only in a very limited way harmonized at the moment. And then there are more specific ex post approaches. For example, the blacklist UCPD, which is now being expanded by the Empowering Consumers proposal. And then finally, soft law is definitely a huge part of the equation. It arises because of a basic necessity by market participants, but obviously it is challenged by governance issues of quality and trust. And it also is not only a full alternative to binding regulation, it might also interact with it, for example, to apply more general ex post rules on misleading practices, for example, there to apply it in practice. Often this huge realm of relevant soft law relating to climate mitigation, for example, the Greenhouse Gas Protocol, PS 2050, and so on, are in practice to decide on a specific case often crucially important. And then finally, binding regulation already now often protects soft law. For example, the current UCPD blacklist, the most relevant provisions, they prohibit claiming incorrectly to have obtained a certain certificate or label or signed up to a certain code of conduct. And the Green Claims proposal would very much expand this. It would actually, for generic environmental claims, require a substantiation of excellent environmental performance in accordance with recognized labels and standards. So that would actually sort of mandate soft law, specific sorts of soft law, to a large extent. I won't have the time to delve in all the possible relevant soft law. Perhaps some of the future presentations will touch upon it. But regarding the product environmental and organizational environmental footprint methodologies developed by the Commission, which is sort of soft law with a public origin, there is obviously the sort of disappointment that it's not in the Green Claims proposal being mandated, but at the same time, this is likely because of the limited scope of these current methodologies, and it's very difficult to try to regulate everything with those publicly approved methodological approaches. So the current Green Claims proposal, although requiring substantiation, has adopted a more open approach where also recognized, established private soft law standards, certificates can be used. Then regarding the behavioral insights, as a general takeaway, especially in the UCPD B2C context, there is sort of a shift that the once taken assumption that a customer is rational and critical is being abandoned. You see there two relevant decisions of the ECJ. And it sort of fits with insight from cognitive psychology. For example, the Tecan decision, it sort of confirms the observation that we often, as receivers of relevant markets communications, take decisions based on our system one, which is very vulnerable to images, colors, sounds, and a lot of climate-related market communications evoke images of a green context and so on. And these are particularly effective, and they should also be taken into the equation of a certain communication, whether it's misleading or not. And then at the same time, the Digital Denmark decision, it sort of fits into the insights that also when we use our system two, and when we try to think rationally, verbal and numeric information, even when it's factually correct, can still be presented in a confusing way, especially in the complexity of climate mitigation aspects. And obviously environmental contextual factors that limit your decision-making capacity are relevant in that regard as well. And this is also where soft law comes in as so important, because that's one of the quality signals that decision makers, not only in the B2C, but also in the B2C context, use. And then the final point, there is research that confirms that mandated disclosures not only has an potential effect on the recipient if he can process his information and wants to act upon it, but also on the transmitter, that by disclosing it, if they then disclose reliable information, regardless of the context, that it has behavioral effects on the actions of the transmitter. And it might also be true ultimately for companies, which in the end are also made up of human individuals that are subject to this so-called telltale heart effects. And then finally, the technical complexity. I think that's, besides the obvious significant stakes, one of the main reasons why there are so many climate washing allegations. I first of all want to highlight pledges regarding future emission reductions. There is a lot of relevant soft law out there, like the PAS 2060 standards on carbon neutrality, but that one is only limited to scopes 1 and 2 emissions mainly. It also accepts almost all types of certified offset credits. And as a result, that's already no longer like the cutting edge practice. There are other standards like Science-Based Targets Initiative, Net Zero, that are more far reaching. And these standards always require also a baseline measurements, of course, and then carbon footprint management plans. And I'm happy to see that, especially in the B2C context, the Empowering Consumers proposal now requires that, or now takes environmental claims regarding future environmental performance without clear, objective, and verifiable commitments and targets, and without an independent monitoring system into account for evaluating whether you commit an unfair commercial practice. It's still a proposal, huh? But at the same time, also the Green Claims proposal, which requires ex ante substantiation, considers claims regarding future environmental future environmental commitments. That's one important issue. There are other complexities, different scopes of emissions, 1, 2, 3, different types of greenhouse gases. For example, a recent US case where Chevron was communicating about the reduction in global greenhouse gas emissions as a result of use of natural gas, but it didn't mention that this reduction was only based on CO2 emissions. And it didn't mention, and that's possibly under EU law and misleading omission, also that there are significant leakages of methane. It already shows that risks in the value chain, different types of greenhouse gases further complicate the picture. And then the big greatest complication is a lot of climate washing relates to offset credits from voluntary carbon markets, where there is a lot of soft law of varying quality, but no real regulation until now. And I don't have the time to discuss them, but most of you will be aware of all the different various types of integrity issues with different offsets. There are now evolving standards. I want to highlight the Oxford Principles for Net Zero Aligned Carbon Offsetting, which first of all emphasize that you have to first of all prioritize your own reductions, and then only for residuary hard to abate emissions you can try to use offsets, and then you should use offsets with high integrity, certified, but then with a good certification, and there is also quite some discussion about what that entails. But especially also offsets that relate to removals. I'm happy to see that Professor Fermeglia will talk about the proposed EU framework for carbon removals within the EU. but these are obviously, from a methodological perspective, much more valuable than offsets that are only based on avoided emissions. Regarding carbon removals and even future geoengineering approaches, there's a lot of technicalities out there. I will skip the very basic discussion that I had prepared, but suffice to say that especially regarding geoengineering, there is a huge risk when trying to make a claim that is partially based on, for example, solar radiation management, that you would be misleading, perhaps only already because of the moral hazard risk involved. And still regarding offsets, I should want to highlight the Green Claims proposal. There is a proposed rule on offsets that you have to communicate towards consumers to what extent you rely on offsets and whether they relate to emission reductions or removals. That doesn't regulate everything, but it's at least a minimum requirements. And then finally, regarding enforcement, to a large extent, especially now with the new B2C proposals, it's not easy. Is climate washing probably not so much an issue of having relevant rules, but seeing those rules being enforced. And although there are many potential enforcement actors, especially public authorities and competitors, especially in cases of so-called reverse greenwashing or climate washing, and there are many potential sanctions of different types, and there are even alternatives to binding legal enforcement like self-regulation, advertisement bodies, activism, and there are especially the Danish Crown climate washing case relating to pork is a nice illustration that activism and market pressures can be a potent alternative to legal proceedings, which are also in this case ongoing. But there is a perceived still lack of enforcement. But after having said that, I want to emphasize that overzealous enforcement, especially also like trial by media that might be not entirely correct, has a significant risk, not specifically for the targeted individual company, which it has, but more a systemic risk that if the amount of trust among the public regarding climate change related communications is completely eroded, and you have sort of chilling effects that companies say, like, we're not going to burn ourselves, we're trying to invest in it and then trying to communicate in the market. If you would be in that future situation, which is now fortunately not yet the case, you have so-called chilling effects, which would be very adverse for having a more carbon neutral transition. So definitely a balance needs to be struck. And then, given that we start a bit later and my time is up anyhow, this is the conclusion. I think it is a regulatory jigsaw, but different pieces of the puzzle actually provide for a regulatory framework that can deal with this issue. And I think to a large extent, although on certain fronts, for example, relating to offsets, definitely strengthening of the regulatory framework is needed. I think the biggest challenge is indeed getting enforcement right. I think in the end, it's ultimately the responsibility of public authorities if there is an enforcement gap to step up, but with that caveat of not going too far. And there is also a possibility for more positive enforcement that NGOs, for example, laud real credible qualitative efforts by companies, and that they sort of get like a bonus for making qualitative contributions. And then as a final note, because changes in the context of climate change mitigation and adaptation, because the regulatory and soft law framework continues to evolve, and also because customer awareness and expectations, both B2C, B2B, evolve, this makes clear that this is an issue that is not going away in the near term, and it will continue to evolve. and be present not only in academic and policy circles, but also in the media, I believe. So with that final note, I end my presentation, and I look forward to any discussion we might have afterwards. Thank you very much.
I will immediately start because we are running out of time with the first panel. And so we will hear 3 presentations. The first will be given by Rita Šimon on sustainability, consumption and greenwashing with reflections on the Unfair Commercial Practice Directive. Rita is a senior researcher at the Institute of State and Law. She focuses on the consumer protection and sustainability consumption from a comparative perspective. She studied law in Budapest and holds LLM degree and PhD degree from the University of Cologne. And she also worked at the Center for Comparative Law at the Charles University and is a member of the European Law Institute. I will immediately introduce the 2 other speakers so then we can follow with the presentations. So the second speaker will be online, and Gamze Erdem Türkelli will shed light on the greenwashing in development financing. Gamze is assistant research professor at the Law and Development Research Group of University of Antwerp, and her work focuses on accountability broadly defined in the intersection of international law, human rights, and sustainable development, and more particularly in relation to development finance, including climate finance. And she authored several books that related to, among others, children's rights. And last but not least, we will hear from the only non-lawyer in the room. So we will bear with Petra Koudelková, and she will tell us about the awareness of greenwashing among Czech consumers. Petra is the head of Department of Marketing, Communication and PR at the Faculty of Social Sciences of the Charles University. She holds PhD in Management and Economy of Companies, and she focuses on corporate social responsibility, sustainability approach of companies, above all SMEs, and marketing and institutional communications. Petra has participated in a project of communication of the Czech Ministry of Education, and she's also author of the Manual for Sustainable Communication Without Greenwashing. So now, Rita, the floor is yours.
Thank you very much for this kind words. I would like to ask for sharing my presentation. Then I will deal with the legal framework, how it is sufficient or not. Elias told us several insights, so I will not try to duplicate them. And final, how the future legal enhancement will fill these gaps. So due to the growing awareness of planetary boundaries and climate change, a significant shift to green economy was forced by the European Commission, but also by national legislation. It's okay. Anyway, so sustainability and green economy became an emerging trend. On the international level, actually already in 1987, the Brundtland Report or Common Future drafted the framework for sustainability development, which was actually 20 years later or more than 20 years later adopted as a resolution by the General Assembly of the United Nations concerning to them. So I'm trying again. Concerning to them, till 2030, all national governments should achieve sustainable development and should create proper national plans for it. However, sustainable development is a universal goal. It's more a general concept which should be manifested through legal and political action, and it's not a legally binding concept. On the European level, it's a little bit different because already in 2002, so much earlier than the General Assembly adopted on the UN level, The Treaty of Niza integrated Article 6 in the Treaty of European Commission, which was later on removed to the Treaty of Function of the European Commission or European Union. But we have actually a binding rule which say that environmental protection requirement must be integrated into the definition and also in the implementation on all European policies and activities, in particular with promoting sustainable development. So with that, in European Union, we have it much more than only a universal code, the Sustainable Development Goals, and they also should be manifested. Due to these rules, the European Commission drafted several initiatives like the Green Deal, the Circular Economy Action Plan, the new Consumer Agenda, Sustainable Product Initiative, Sustainable Finance Action Plan, and also finally the European Climate Law. So sustainable development goals should be achieved. This increased not only the pressure on companies, but they saw also potential benefits in financial performance and also in reputational capital, and how it is usual in new markets. The principles first come, first served got in force, and the market were overflowed with unfair claims or unfair green claims. Only to mention some, the 7 sins of the greenwashing will be more elaborated by Petra. So we saw several claims, for instance, that some oil products are environmental, or the vacuum cleaner is the most eco which is existing. However, it did not perform better than similar in the group, or it was given on the product documentation that is biodegradable, however, no certification or something will performed. Other cases will Petra mention, but carbon removal or zero CO2 claims are visible everywhere. The greenwashing was also defined by the Oxford English Dictionary. However, we do not have a concrete definition still in the European law, which says that this is a disinformation disseminated by an organization to present an environmental responsible public image. Several companies, but also organizations like FIFA facing lawsuits for engaging in false environmental advertising. What are the subtypes of greenwashing? Greenwashing cases, how Elias already mentioned, are manifold. The most comprehensive climate claims. Should I start again? The most comprehensive clarification and typology for climate litigation was delivered by the Sabin Center of Climate Change at the Columbia Law School. However, they do not classify a separate sub type for greenwashing. Greenwashing claims you can find under financing and investment claims, misleading advertisement, or disclosure. However, I think there are several other categories which could be detected concerning to them who is causing the misleading claim or action, to whom. We can diverse between B2B, B2C, state to community, or businesses to state. actions. Concerning to that, which stage the claim is mentioning, we can diverge between production, transportation, or usage, or recycling claims, which type of business activity the claim refers. It can be crediting, marketing, sale of products, or reporting, or future pledge. And the fourth clarification, what I found, where the claim is manifested. So it can be a text, it can be graphic, a product name labeling, or the combination. Each of these type have very different problematic, and from this I think it's very visible that the judicial control over these claims will be very complicated and comprehensive. What are the disrupting effects of greenwashing? I would like only to mention three, because Petra is much more, as an economist, is much more familiar with that. So it first undermining the competitive advantages from those firms. They are really willing to do something for the environment and to tackle the climate change. So their cost will be not reimbursed because the consumer will not buy this product. It eliminates at the end the motivation toward the whole green performance. It destroys the trust in eco-labels, which are very expensive, and their publicity is very costly and lengthy. So it's very, very negative effect. And at the end, last but not least, it is disrupting consumer decision making. Because we are all familiar with that the European markets are liberal markets and there is no regulation of consumption. We have only this information approach. So the information paradigm is the most important. Therefore, it is really important what kind of information the consumer gets. Therefore, the information asymmetry is even worse if the information is not correct. So due to this, I would like to say that greenwashing is something like fake news and personal advertisement altogether, and it will be very negative for the market. Comprehensive and environmental accurate information and also trustworthy climate indicators are indispensable for enabling consumers to make this more sustainable choice. So to create the critical mass on consumers, they will really act more sustainable is a huge issue. How the law is tackled this issue? Elias already mentioned, so I will just summarize what kind of legislation we have. How you can see in this picture, it's very fragmented and multi-layer legal framework. I tried to create some pillars or some a nice picture, but it was not manageable because they are so different, these rules, not only depending on that whether they are horizontal or only sectoral, but they also tackle very different issues. So only short, we have sector-specific regulation, which has some important information for the consumer. For instance, if we are thinking on the energy efficiency of some products, then the consumer can see if it is A+ or only A. But it regulates how companies should label their product. We have horizontal B2B framework against misleading advertisement, which is important and has also a positive effect for the consumer, that they will not have so many misleading advertisements on the market. And we have also sustainable disclosure and reporting rules, which are growing. There are several initiatives also in the pipeline, but they will not deliver directly information for the consumer. Probably the market surveillance or banks or maybe some competitors will control this disclosure. The consumer will not read them. We have a eco-label regulation. It's a very old directive. Actually, it was a directive, now it's a regulation. It includes important information for the consumer, but only in the case if the eco-label are correctly certified and the manufacturer do not use some similar label, which seems like a European label, but it is not evidenced. And on the top of this very diverse framework, we can find a horizontal directive on unfair commercial practices, which is today one of the key, or it is actually the key regulation where a market authority can really control the claims. However, when the European Commission made the screening of website in 2020, they found that half of the green claims lack evidence. So it seems that this multi-layer legal framework do not make its job. It's not sufficient, and how Elias already mentioned, the enforcement is very diverse among member states. For instance, in Czech Republic, we do not have a greenwashing action or suit at all. There are other countries, Belgium, Netherlands, Germany, Austria, where we know about many cases. So in Italy also, the enforcement is very diverse. Whether the authorities has clear guiding principles, guidelines, it's also questionable. However, we should say that since 2009, the European Commission make regular guidance also on environmental claims, but it seems that not all market authorities is using the sovereignty, and they are not controlling in that intensity how it should be. So future enhancement. Already in 2012, Nick Feinstein announced that it is necessary to learn from the past mistakes, and we should regulate and prevent the greenwashing due to its negative effects. But it seems that the regulator is reacting very slowly. In the pipeline, we have amendments on the UCPD directive to create a better safety net. We have also a proposal on green claim, which will have a scope everywhere where no other sector-specific directive exists. So it's actually will fill the gap, but the question when the green claim directive will get in force. We have also important information which is in a pipeline in the digital product passports initiated by the Sustainable Product Initiative, but we also do not know when the digital product passport will be effective on the market. One slide on the future amendments from the UCPD directive. We can say that finally an important key definition will be made. So environmental claims, explicit generic environmental claims will be finally defined by European legislation. We will have also some clarification what is a sustainability label, what certification schemes should be recognized, and what is a sustainability information tool. next to the existing or beside to the existing misleading practices, 2 new misleading practices are mentioned. The first, the environmental claim without a clear, objective or verifiable commitment will be a misleading practice. And also when the advertising which should benefit for the consumer actually is only a common practice on the market. One new misleading omission is prepared when the sustainability comparing tools will not have information about its methodology or the product groups with it will compare, it will be also a misleading omission. And 4 new blacklisted action are drafted. Some academics say that these blacklisted actions are too blind and too unclear. However, if we do that, the enforcement needs very easy actions and very easy clarifiable rules, then maybe it will help them at least combat the blacklisted actions from the market. So to summarize that, the new UCPD proposal will cover all 7 sins which was mentioned by the Terra Choice study in 2007. And further, it will also combat the sin of advertising a common practice, advertising feature which were imposed actually by law, and also a sin of vague comparing tools. But unfortunately, we can confident that interpretation issues will be also in the future. The field is often very technical. It's not easy to show that it's a misleading claim. We can confident that the national market surveillance will act very differently. The sanctioning mechanism will be also very different. And how I already mentioned, the UPC scope is very limited only to B2C sanctions, so it will not cover everything. So thank you very much.
Thank you so much to Monika and to Hanna also for the invitation. And I'm really sad not to be in beautiful Prague, one of my top 5 favorite cities in the world. And thank you to the speakers. I think it really falls well after hearing the 7 sins, but also the regulatory frameworks. And what I'd like to talk about this morning is more the outward-looking perspective of what big donor countries or groups like the European Union, when they transition towards a more sustainable economy, so the green transitions, what happens to, well, how do we finance that? What happens to the rest of the world? And let's see if I can change. Yes. So a lot of our, well, my research is informed about how to deliver human rights that are public goods, but also how to deliver sustainable development more generally throughout a legal framework that is a mixture of hard law, so treaty law based on environmental treaties and human rights treaties, but also a lot of soft law instruments. And I think the previous speakers went into depth in mentioning the fragmentation, but also the different levels of governance that take place. And so the idea is that we really have this development financing gap, so sustainable development financing gap. It's research that has been undertaken by the IMF, the World Bank, the UN Development Program, among others. And so when you look at this graph, you see that, yes, in order to be able to achieve the educational aims or the health aims, or the infrastructure aims of the UN 2030 framework, the 2030 agenda and the Sustainable Development Goals, we need massive amounts of money. We need much more investment than we currently have. And so the idea is that we need the private sector to come in, because this is just on a scale that we cannot, with public resources, attain. And so we've been seeing since 2015 the so-called leveraging concepts. The World Bank came out with from billions to trillions. So by using public resources and incentivizing private investments, that we would see that multiplier effect, that leveraging effect that was going to be able to deliver this kind of this scale of resources needed. And so how does that link to our topic? We're seeing more and more a greening in development finance. Of course, things like climate finance have a legal basis. So the UN Framework Convention on Climate Change, there is a provision that says funding and financing should be made available, especially to developing countries, in order to be able to meet their adaptation mitigation goals. But it's the latest surge is really guided by the move towards a greener economy. So the green transitions that are combined with those discourses around the SDGs investment gaps. And so we're seeing more and more innovative finance models. So how does the money, how is the money going to come? How is the money going to appear? We're seeing different financial instruments like green bonds, blue bonds, believe it or not, rhino bonds. So biodiversity conservation bonds. These are financial instruments that would have been used for purely financial reasons, and now they're being attached a sustainability purpose, be it better green urbanization through green bonds, ocean conservation through blue bonds, or really the conservation of rhinos that are going extinct in Africa. So we are seeing more and more that sustainability links, greening links in financial instruments, and they are also coupled with development finance very closely. And as a background to how these connect with, for instance, what we've been discussing at the EU level, green deals that want to foster that green transition and that have been adopted in the EU and the US are accompanied by development finance plans abroad. And those programs and plans, they are quite closely linked with geopolitical considerations on where development financing will go, should go. And there's now on the slide a quote from Josep Borrell saying that the global gateway, which is basically the arm that is the world-facing arm, the financial arm of the, I would say, the green transition and the Green Deal at the EU level, it links EU support for investment in emerging and developing countries, economies with the EU's geopolitical objectives. And these are very clear in the documents and the legal documents that set out these instruments. And implicitly or explicitly, there's always a point that China, as one of the new biggest investors around the globe, especially in developing countries, should be countered with a proposition that is values-based, that is greener, and will propose to people in developing countries a different alternative, but still being focused on infrastructure and energy, which are also highly demanded in developing countries themselves. And so how does all of this link to greenwashing? So first, we need more money for the SDGs. we must transition away from fossil fuels now. So the latest reports, of course, from the Intergovernmental Panel on Climate Change tell us that we don't have much time, that this needs to happen now. Well, we need to bring in the private sector, that's the discourse, and incentivize them with public funds because we have that huge investment gap. And then we have voices from civil society, from developing countries themselves as well, saying, well, what is going to happen to the people in the developing countries and the planet? And why are we looking at people in developing countries? Because we know for a fact that many people in, for lack of a better term, the global south will bear the brunt of climate change, the climate emergency, much more severely and much faster, and in ways that are more immediate than the rest of the world. And so what about, how do we know that these new proposed investments are green? What about greenwashing? We need to, then we have this perspective of governing those investments so that they're sustainable. And here you see, because we've been speaking about the European Union, how the European Union internally is planning to finance its green transition. And of course, it's also a reminder that sustainable development is something that is also trying to be achieved in wealthy parts of the world. So there are still development efforts that are being undertaken in wealthy countries themselves, but there's that huge accent on public-private partnerships and the public finances working together with the private sector. And that can be private sector that is the financial sector, but also all of the different manufacturing sectors, the services sectors that we have been this morning talking about that are also consumer facing. So indeed, those companies and private sector actors that also need to green their business models or their supply chains, their value chains, products will also make an appeal to funding. And that can be in the form of research funding, that can be in the form really of just finances to change business models. And when we're going towards the outside, and especially in developing countries, I see really that there are multiple risks of greenwashing, but also rights washing. And of course, this is because I work in human rights law, mostly when I connect the political economy of sustainable development to the law, I do it from an accountability angle, and that accountability is much more informed through my work in human rights. So I also see that there's a rights washing risk that comes with this new discourse around transitions. And there are four big risks that I will speak to. One is the privatization of investment governance. The second one is the use of risk-based models. The third one is what I will call wolf in sheep's clothing types of investments. And finally, commodification and marketization. So privatization of investment governance. And I think this links to the debates around fragmentation, but also to the various levels of governance that I think our keynote speaker really in depth and very eloquently already spoke to. So partnering with the private sector brings, of course, challenges, but it also often brings private legal agreements that are governed beyond the scope of public international law or domestic law. So a lot of contractual relationships, or sometimes a lot of investments that go through bilateral investment treaties and such, where it's really hard to challenge those investments for instance, for being green or for greenwashing, for instance, these kinds of private legal agreements don't leave much scope to challenge whether a supposed green investment is actually green. And then we have a myriad of governance frameworks that are really, it's really unclear which of these frameworks will apply when to whom. We have international human rights law, environmental law, we have domestic law, of course, in states. And imagine they're an EU member state, then you have that complexity of having EU law, national law. You have also, under certain legal regimes, like the EU, the taxonomy, which will be relevant not just to EU member states, but of course to investments across the board globally, because EU is the home state to a lot of big investors that will start using those frameworks. We have softer frameworks like the United Nations Guiding Principles for Business and Human Rights that are not binding, but have been, well, states have been working with them for more than 10 years. They deal with human rights and they don't really, to a very deep extent, incorporate the connection between, for instance, human rights and the environment, which is now, you know, more and more an accent that is being drawn, especially with the right to a healthy environment being recognized, or en route to being recognized as a part of the human rights compendium. We have similarly OECD's guidelines on multinational enterprises. Again, these frameworks don't really take into account so far those links, close links between the planet and the people and prosperity as they are set out in the 2030 agenda. And we have these famous ESG standards, environmental social governance standards, that apply, well, that are being formed. Some of them are being formed at the sector level. Many of the toolkits are really private. So they might come out of auditing firms, they might come out of sectoral organizations, and it's still unclear how they will connect with the legal framework. So the hard law that will allow us to, for instance, challenge investments for being greenwashing. And then the second risk is, well, basically the use of risk-based governance models instead of rights-based models. And this is a bigger debate in business and human rights, but if we end up using corporate due diligence models of assessing risks, not as risks to rights holders and the environment, but just to corporate reputation or costs, then we'll also risk rights washing. So we talk about green investments, electricity powered vehicles, but now we also have to talk about what the mining of those metals that enable our nice electric vehicles do to the environment and to the people that inhabit that environment, most of them in developing countries. There's a danger of diverting public resources from regular budgets to achieve these public policy goals to the private sector under the guise of green investments. Commodification and marketization. So everything becomes an opportunity for green sustainable investments. There are new products that come out saying, well, and some of them I think Petra just outlined might not really be true. There are new financial products that and services that are also branded as green. And even worse than, I think, consumer products, in financial products, we can't really do the checks and balances so easily by checking how the financial instrument works, because there's a lot of risk and it's really hard to predict. There's also a new market for ESG consultant compliance products and services. So we're seeing, again, it playing into the markets. Wolf in sheep's clothing investments are what I call it as such because sometimes investments that a company does just to diversify its portfolio will be rebranded as green or sustainable, including fossil fuel producing companies that are making record profits, still saying that they're investing in renewables. And sometimes geopolitically motivated investments might be marketed as green, but but they're not in core. And finally, just to finish on time, hopefully, I think we need to keep in mind that the green future, whatever it might be, and however it might be constructed, should prioritize the needs and the interests of rights holders, whether they're humans, non-human, animals, or nature, and that we should be really cognizant of creating opportunities that actually diminish public resources that are available to realize, to meet those needs and realize those interests. Thank you so much.
Good morning, ladies and gentlemen. My role is to speak about the awareness of greenwashing among Czech consumers. I think it's a very interesting topic and important topic because consumers want to buy green product, and the number of green products in our stores has skyrocketed in the past 2 decades, which could be great, of course. The reason why I'm interested in this topic is that my students are going to be marketers or communication specialists. And we know that advertisement could influence our thinking and decision-making process and so on. And this is the reason why it is necessary to play fair. Firstly, I would like to show you this graph. It's from the Czech Marketing Association. This association make the research about perception of advertisement every year. And interesting is the first figure. Okay, the first figure says advertisement manipulates people. That means the respondents tend to have a negative attitude to the advertisement, and it could be worse if it gets a better reputation for greenwashing. And we don't want it, because information from advertising could be helpful if you solve some problems or issue. And from economical point of view, it could be also information from information from advertisement could be competitive advantage. But back to the greenwashing, I want to repeat the definition of greenwashing, and I will speak about 7 sins of greenwashing. So, okay, the number 1 sin of the hidden trade-off. It describes a situation where an environmental issue is seemingly solved, but this solution contributes to another concerning issue. Maybe you know the scandal about paper straw by McDonald's. I don't know if you remember it. McDonald's replaced plastic straw with paper alternatives. Unfortunately, the paper straw weren't recyclable, but the plastic were recyclable. And it was a big problem because a small reduction in plastic consumption, although it step in the right direction, shouldn't be applauded as a completely sustainable move without addressing a challenge of waste reduction. So doing so would make McDonald's guilty of the hidden trade of. The next one, sin of no proof. It describes environmental claims that are not backed by factual evidence or third-party certification. An example would be claiming that a certain percentage of the product comes from recycled content, as you can see, without providing supportive factual data or details. Probably, you know, these labels, it's from H&M, FNF, and many others. So next sin is sin of vaguenesses. This sin describes environmental claims that lack specificity and so they are perceived as meaningless. The sin is committed when using words such as green, sustainable, eco, organic, and other, without a specific explanation to justify their use. Their overuse and the absence of clear set criteria has led to the dilution of such terms, rendering them meaningless and interchangeable. Next sin is sins of irrelevance, where there may be a claim that is true, but it's completely irrelevant to use it on the production or on packaging because it is something what is regulated by the law. As you can see, phosphates or freons are typical examples. Number 5, sin of lesser of two evils. It's example from the Czech Republic. I hope you can see it. It's benches from by McDonald's. These benches are made from old plastic food trays. I think it's a good act, according to me. But what is problem that McDonald's made only 3 or 4 benches, and he used this act as a main message in their communication campaign. Yeah, so it's not ethic because you can use only one small positive step and hide the rest of negative action. Number 6 is sin of fibbing. The sin of fibbing describes environmental claims that are blatantly false. Here is example of H&M. It was sued in New York Federal Court in July last year, sorry, for trying to dupe eco-constitution consumer willing to pay more for green products with a clothing range that feature environmental scorecards in the labeling, packaging, and marketing. The idea of the scorecards was to inform the consumer how sustainable an item was, but the company ultimately had to scrap the idea after a Dutch regulator ruled that it had used falsified information that didn't comport with the underlying data. And here is a sin of worshipping false labels. It describes the creation of false certification and eco-labels. Maybe I ask you if you know any of these pictures, any of these eco-labels. all of them are fake. But with the third, the paper is not artificially bleached. You can met it in KFC. The second one is on packaging on some shampoo from Italian. The first one, it's my work in Canva, sorry. It's only for my students. Well, and now a few words about the research, and we can talk about Czech consumers. The research, for the research was used quantitative methods for data obtaining. Questionnaires were distributed to go to Czech Republic to ensure reliability of the research. The research was conducted in spring 2022, and women and men from 18 years were involved to the research. We got 148 valid response, and questionnaire was divided into 7 sessions. I will present only one of the sessions, which is focused on greenwashing. The first slide is about awareness of concept greenwashing. The respondents were asked if they understand the concept of greenwashing. As you can see, less than half of respondents know the term greenwashing and are able to explain what the greenwashing is. So more than one half of respondents don't know what does it mean. These data are from the whole Czech Republic. When we work with respondents from the Prague, Brno, Olomouc, and Pilsner, and the cities or villages around Prague, so the situation is different. Almost 96% of respondents from these places understand the term greenwashing. That's good, but the rest of the Republic has this disadvantage. As part of the open question in the survey, the respondents were asked to further define the concept of greenwashing. So you can see the answers like marketing commitment for eco products, or we often met the answer like, I know the word, but I don't know what meaning. Often is mentioned greenwashing is brainwashing. And what was surprising for us that nobody mentioned health washing, because sometimes is health washing perceived as the same or very similar as greenwashing. And interesting is also the last sentence. I have never heard this term. I think 3 or 4 of respondents mentioned this sentence. Then we also ask if or whether the respondents are interested in sustainable products and sustainable services and so on, because our hypothesis is that the people who are interested in sustainability as well face the greenwashing often the people who aren't. So the young people around 20 to 30 years, let's say, are interested in sustainable products and sustainable services. This is the green color, and the red color it shows people who aren't interested in, and they are mostly older people. And here you can see the compare people who are interested in sustainable products. So you can say it's almost 200 respondents, but only 155 of them know the term greenwashing and are able to explain it. And now the question is what to do. Is greenwashing a problem for the society or not? We know that the consumers want to buy green products. Unfortunately, customers are also limited by their knowledge about the topic and by the time to verify some claims and information on the packaging. And the companies know it very well. And sometimes they use this opportunity, yes, and we still met misleading information on the packaging or on the products. It's not fair, let's say. And then next problem could be that marketers from the Czech Republic don't have any clear regulation on green labels, greenwashing in the Czech Republic, and they often don't know any regulation or directives from the European Union. For us, like for communications specialist, let's say, is important green claim directives. I think you know it very well. But when I ask my colleagues from agencies or from companies, they don't know anything. They don't care. It's not important for them, unfortunately. And what is also a problem, that is the communication practices are very sophisticated. It's much more sophisticated than it was several years before. And it could have a negative impact not only on our environment, but also on customers, because customers could stop believe in environmental traits, or then can stop believe in really green products. And we know that Czech consumers oriented according to eco labels, according to certification. And what is funny, don't know what does it mean. Don't know maybe Czech eco labels or certificate like Plasa and so on. They are absolutely misleading in certification of European Union. So for companies, it's easy to make their or certificate or some eco label or some picture. So it's a really big problem. And we also asked our respondents what to do with this situation. They suggest some education. I mean, the regulation is the first, of course, but they mentioned education, and the question is who should educate the consumer. So they suggested schools and universities, of course, I agree with this, and then companies. But the problem with the companies is that the company often don't have the scientific or experts on specific topic. It was, for example, the problem with Penny and the campaign Save the Bees. And when they have some experts, let's say, so there is problem with the trust because on concern of Andrej Babiš, so people, consumers don't want to believe companies who are from this concern. So, and as I said, it's not easy for our consumers to recognize what is greenwashing and what is green marketing, what is false and what is bad. And 7 cents isn't sufficient. We need to speak about more green, more sense of greenwashing. For example, next sense could be questionable pictures and colors. Here you can see the example. The colors brown and green is often used on packaging. But I think the better than sense of greenwashing is speaking about greenwashing strategies, because big companies are very well into making some communication strategies. And the first one we mentioned, the strategist is Planet Tracker. And in this publication, you can find strategies like green labeling, but also it's green labeling cover the sense as vagueness, irrelevant, and fibbings. So green labeling and the next strategies are green shifting, green rinsing, green crowding, and green hashing. So it's from Planet Tracker. Yeah, I think it's everything from my side. It was really briefly about the sense of greenwashing and our Czech consumers. Thank you for your attention.
Thank you very much, Petra.
So welcome again to our workshop. I'm delighted to moderate the second panel. We will have 4 great speakers. First, Ekaterina Aristova, whom I would like to ask to share her presentation. After her, Emilie Jane Coutin from Highbridge Law Firm, Copenhagen. Then Monika Feigerlová for our Institute State and Law. And Matteo is still outside, but I hope he will join us later and he will have the final presentation. So let's turn to Ekaterina Aristova. She is an early career fellow at the Bonavero Institute of Human Rights at the Oxford University. Her main research interest is a field of business and human rights, and completed her PhD studies at the University of Cambridge on strategic litigation against multinational enterprises. She also holds a legal degree from Perm State University and the Russian Presidential Academy of National Economy and Public Administrations. So the floor is yours. We are happy to hear your presentation.
Hello, thank you very much. I hope you can hear me okay and can see my slides as well. Well, thank you very much for having me, and thank you, Monika, for the invitation to this insightful workshop. I really enjoyed the first panel and I'm learning a lot on this area. So I'll talk today a bit about greenwashing climate change litigation. I just want to introduce the Institute, the Bonavero Institute of Human Rights, for anyone who is not familiar with our work. So we are the dedicated human rights institute within the Faculty of Law in Oxford, and my colleagues and I run programs, a variety of programs on democracy, rule of law, human rights, and we Hannah said that the purpose of the workshop was to explore collaborations between climate change institutes. Well, while we're not a dedicated climate change institute, we do investigate those intersections between environmental harm and climate change and human rights and some broader issues. And so my project, the current one that I'm coordinating, looks at climate change litigation against corporations in general, which is, as many of us know, is on the rise. And according to the London School of Economics, climate change litigation has more than doubled globally in the past 7 years. And there are now over 200 cases brought specifically against non-state actors. We are focusing today on greenwashing. It's hard to say how many number of those claims are exactly there, and partly because of the terminology, as it was already examined today that the term greenwashing can take several meanings. So I'm referring to a practice of making misleading statements and portraying activities, products, or companies as more environmentally friendly than they actually are in order to attract consumers and investors. And in total, we are speaking about a few dozens of those claims that are litigated now in different jurisdictions. So just before we start, before I give you actually a few examples of those claims, I just want to tell a little bit about the regulatory context that we are operating now. Companies are increasingly disclosing information about their human rights, environmental performance, and climate-related information. And there is both mandatory ESG-related disclosure, but also increasing voluntary disclosure. And while there is no single law or regulation that prescribes companies to be more transparent and to expose their non-financial information, those requirements can be found in different pieces of legislation, for example, corporate law and securities laws, or dedicated sustainability disclosure and human rights due diligence legislation. Since I'm joining from the UK, I can give you an example of what English companies are required under English law. The Companies Act requires large and medium-sized companies to publish an annual strategic report, which must include information about the business's environmental impact, social, community, and human rights issues. And last year, the Act was updated, and now over 1,300 of the largest UK registered companies are also obliged to disclose climate-related financial information on a mandatory basis. In the EU, since 2017, largest companies comply with the EU Non-Financial Reporting Directive, which has been recently expanded by the Corporate Social Responsibility Directive. And we're also looking forward to the adoption of the EU Sustainability Due Diligence Directive, which will require companies to also publish a climate action as part of their reporting. There is also increasing voluntary disclosure. Many companies now publicly adhere to the UN Guiding Principles on Business and Human Rights or UN Sustainable Development Goals and adopt voluntary codes of conduct, or adhere to the multi-stakeholder partnerships and sectoral and industrial documents such as Principles of the Responsible Investment or Global Reporting Initiative. And moreover, there is an increasing pressure from the investors. I just put examples of three groups operating in the UK that engage in the dialogue with the companies and trigger the more disclosure and transparency and encourage responsible investment. So as an outcome of all of those developments happening, that corporations now increasingly make climate statements, they announce climate pledges or ambitious commitments to reduce greenhouse gas emissions. And as a result of this increasing disclosure, they expose themselves not only to reputational risks, as we already had from the first panel and the consumer awareness, but they also expose themselves to legal risks and being increasingly challenged under consumer protection legislation about the commitments they're making. So I just put a few trends that can be evident in the climate-related greenwashing litigation. So first of all, we can see lawsuits that challenge different types of misleading statements. So on one hand, we can see claims that relate to overall corporate net zero commitments. So for example, if the company is saying that they will reduce their emissions to a particular level, or if they aim to achieve a net zero to a particular year. But there are also, there are also claims that challenge particular product attributes. For example, if the meat producer is putting a label on its pork being environmentally friendly, but actually that doesn't comply with the practice, then he can be brought to court as well. And the second group of lawsuits is more numerous ones. And the strategies that the claimants are employing, well, they allege that claims are false, they lack information or methodology that could help to evaluate communications, they use vague or ambitious language. So it's all very different strategic approach that is being used. There are also multiple types of defendants that are brought to the courts or other forums, and it's not only the fossil fuel companies, but also airlines, meat producers, fashion brands, financial institutions, and many other sectors. And it's in line with what Elias was telling today about how climate washing is such a broad concept that it doesn't only apply to energy sector, but it does apply to a wide range of companies operating in different industries. And then the final trend that I want to acknowledge is that litigation arises in different fora. And of course, this comes back to the terminology, because some experts only treat litigation as lawsuits happening in the judicial forum, where I'll take a bit of a broader approach, and we can see the lawsuits in domestic courts, but also non-judicial governmental authorities, for example, competition or human rights commissions, but also quasi-judicial bodies such as national contact points under the OECD guidelines for multinational enterprises. So give you a few examples of the claims. So quite interesting group are those lawsuits that are challenging misleading corporate net zero commitments. There's not so many of those claims but we the experts agree that there will be more and more coming in the next few years. So many of us know that under the Paris Agreement, or most of us, as you know, that under the Paris Agreement, states are committed to reduce their emission by 45% by 2030 and to reach net zero by 2050 to reduce global warming. And increasingly, along with the states, non-state actors also announced net zero commitments and pledged to reduce emissions as well. And civil society organizations are now increasingly bringing corporations to the courts to challenge those. So the first court case globally, which is claimed by Australasian Center for Corporate Responsibility being the first one, was brought in 2021, and it's again against oil and gas company Santos, and it relates to the representations that its natural gas is a clean fuel, but also that a company has a credible net zero commission plan. Santos has indicated in its annual report that it will achieve net zero by 2040, and what the center is trying to establish that it's not achievable because the company plans to continue expanding its oil and natural gas operations, which is misleading, and this expansion will prevent Santos to reach this commitment. Those are the cases ongoing. The case brought by Greenpeace France mirrors the same strategy, and it's the first case of the type in Europe. It was brought in 2022, and it targets Total's claims to be aiming for net zero by 2050 and becoming a major player in energy transition. And their argument used by civil society organizations is pretty much the same. As long as Total continues to expand its oil and natural gas operations, it won't be able to meet this commitment. And then the second type of the claims, which are, as I said, more numerous, are misleading communications regarding product attributes. So the databases that maintain the record of those cases, for example, indicate that there are at least 12 German cases that are brought against different types of companies, manufacturer of bean bags, heating oil, food products, grave lights, candles, and they all follow the very similar pattern that corporations put the labels that these products are environmental friendly and climate friendly, but that's actually misleading. And the success rate is quite high. So in all of those cases, almost I think 10 out of 12 have now been finished, and the decision was in favor of the claimants. But there are also those lawsuits happening elsewhere. So there is one in Denmark. I put it in the slide. The airlines are increasingly challenged. I put the example of the KLM case that was brought in Netherlands, but there was a claim, similar one, brought against another airline in the OECD guidelines for multinational enterprises, and the FIFA was challenged. I think I put here, this is the case from the UK Advertising Authority, but a similar claim was also brought in Switzerland about the claims that the World Cup was carbon neutral. And as I've said, the success rate of those type of claims is quite high. I'm mindful about the time, so I don't want to delay us any further, so just want to say a few concluding remarks. So greenwashing claims will continue to rise. At COP26, the UN Climate Conference in Glasgow in November 2021, the UN Secretary General announced a new high-level expert group to establish clear standards to measure and analyze net zero commitments from non-state actors. And so we might expect that this group will be active and there will be more and more investigations, but also those investigations are happening at the domestic level. In UK, the Consumer Protection Agency published a clean and green code, the way it's called, and it puts some methodology on how net zero commitment statements should be assessed. And there are now ongoing investigations into fashion brands, for example, into ASOS, Boohoo, and Asda. The George brand about testing to what extent those commitments about fashion being environmentally friendly is a correct one. And of course, we might remember that there is a change in regulatory landscape in relation to mandatory human rights due diligence, and we are all expecting to see the EU Directive on due diligence being adopted in the nearest future, which also encourages climate-related disclosure. So if there is one takeaway that I would like everyone to have by the end of my presentation, is that probably the company is now in a very different regulatory and legal arena as it was in 5 years ago, and they don't have now luxury to publish empty slogans or ambitious promises without actually investing into appropriate due diligence and into appropriate measures to uphold those statements. I'll finish here, but I'm very happy to answer any questions that the audience might have. Thank you very much.
Now I'm turning to Emilie. Emilie Jane Coutin is our next speaker. She has Master of Law from the University of Copenhagen and a Bachelor of Law with the European Legal Studies from Newcastle University. She focused and focusing on international climate change law and completed her master thesis on the EU Taxonomy Regulation. And currently she is training to become a qualified lawyer at Highbridge venture capital law firm in Copenhagen. So her speak will about the new approach to greenwashing under the EU Taxonomy Regulation. The floor is yours.
Thank you. Okay, hello everyone. My presentation is about two different legal regimes which are both aimed at preventing greenwashing. And so as you all know, the taxonomy regulation is hopefully going to address greenwashing in the future. And I'm interested in the new approach that the taxonomy regulation takes as compared to the legal regime which we've had since 2005 in the form of the EU Directive on consumer practices, unfair consumer practices. So the taxonomy regulation, as I describe it, if you can go to the, oh, that's my job. The EU taxonomy regulation takes what I call a positive approach to greenwashing, insofar as it imposes a obligation of disclosure on financial companies, where financial companies need to provide their investors with information about sustainability of their portfolio companies. And if people are not familiar with the taxonomy regulation, then maybe we can open the compass, which the taxonomy compass is a relatively user-friendly tool which sets out the technical screening criteria which are set forth in the delegated acts of the taxonomy regulation. And here, for example, if you want to construct a new building, then you go under construction of real estate, construction of new buildings, and you can see the quantitative sustainability criteria which you need to comply with in order for your this economic activity to be considered sustainable. So it's very clear quantitative standards about what it means to engage in a sustainable activity. Thank you. This can be contrasted with the approach which we have seen for the last few decades. And the reason I call it the Danish approach in quotation marks is because the Danish approach comes from this European directive from 2005, but has been developed over the last 2 decades by the Danish Consumer Ombudsman. And there's have become much more developed rules about particularly environmental claims and claims on sustainability. And so until now, greenwashing has really been equated with misleading advertising, and that's the way in which it has been regulated. And the important difference here is that the negative approach under the EU directive and the Danish practice means that the documentation which will prove whether a certain act is greenwashing or not is not available until after the authorities think that or suspect that greenwashing is happening or misleading advertising. So it's or post the act that the information becomes available whether or not greenwashing was in fact happening. And it's a negative approach because we prescribe or we prohibit misleading advertising, whereas the taxonomy regulation takes a positive approach by requiring the publication and disclosure of sustainability related information. So it's very interesting to compare these two approaches and consider how they are going to be harmonized going forward. And in terms of how they regulate greenwashing, it's very interesting that neither of them directly regulate greenwashing. So the Marketing Practices Act, as it's called in Denmark, regulates misleading advertising, and the taxonomy regulation regulates disclosure. So they're both intended to prevent greenwashing, but both of them do so without actually addressing the concept of greenwashing in the act or even in their practice. So in light of this, what approach do both of these legal regimes take to the definition of greenwashing? As we heard before, under the taxonomy regulation, there is a definition in the opening recitals of the regulation, which says that greenwashing refers to the practice of gaining an unfair competitive advantage by marketing a financial product as environmentally friendly, when in fact basic environmental standards have not been met. And this definition can be qualified by 2 things. First, that it is not a legal definition. It's not used for the implementation of the taxonomy regulation. It only is found in the recitals of the regulation. And if you read the full recital of recital 11 in the taxonomy regulation, then it's actually not necessary. It's setting on the background context for something that isn't actually directly relevant to the implementation of the taxonomy regulation. And the second qualification to this definition is that it is only relevant within the context of the taxonomy regulation, which applies to financial companies. And the taxonomy regulation regulates environmental sustainability, which I'll come back to. And it's interesting to note in this definition that it doesn't mention the word sustainability, and it mentions marketing financial products as environmentally friendly, and there's reference to environmental standards, even though the whole regulation is based upon implementing a new common and accurate understanding of what it means for something to be environmentally sustainable. Environmentally sustainable has 4 different sub points which need to be fulfilled. The first is that the relevant economic activity has to substantially contribute to one of the 6 environmental goals. The second is that it cannot harm any of the remaining goals. And the third is that the general international guidelines on human rights, including the OECD's recommendations for multinational companies, need to be upheld, and the technical screening criteria relating to sustainability in terms of the environmental goals needs to be complied with as well. So the point is that the taxonomy regulation does not regulate greenwashing. It's imposing disclosure requirements, and the indirect consequence of that is that it should be more difficult to greenwash when there's so much information available to investors about whether or not a particular investment would qualify as sustainable. And so in general, there will be more transparency, which is hopefully going to prevent greenwashing. Under the Danish system, and there may be a very similar system in other EU member states, depending on how they have implemented the 2005 directive, the Danish Consumer Ombudsman has introduced several guidelines, and the latest of that was from 2014, where they set out the documentation requirements for environmental claims and claims regarding sustainability. And the Financial Supervisory Authority is the body which is responsible for applying these guidelines and the rules under the Marketing Practices Act, and now the Taxonomy Regulation in respect of financial companies. So if a company makes an environmental claim, there are certain requirements as to being able to document that claim, and there are different, more onerous requirements when the claim is regarding sustainability, because as we know, sustainability is a broader concept. The interesting point here is comparing the approach to defining greenwashing or addressing greenwashing under both of these systems, because the EU Taxonomy Regulation is concerned with environmental sustainability, and the Danish authorities explicitly distinguish between environment and sustainability. And as a side point, the Green Claims Directive, which at some point may come into effect, largely reflects Danish practice. There aren't many material differences between the practice and that the Danish authorities have developed and what would come into force with the Green Claims Directive. So this conversation is very relevant. So we end up with this this gray area where where we need to understand what it is we mean by environmental sustainability, and the reason and what it is we mean when we're looking at more generally at misleading advertising, because as I said, the taxonomy regulation is only going to be relevant for financial companies in terms of environmental sustainability, and is going to supplement the existing regime going forward. So we're still going to use the Marketing Practices Act to address misleading advertising and greenwashing, but we need to understand how we're going to do that now that this new regulation has a different approach to environmental sustainability than we've seen so far under the Danish authorities' practice. Just to provide an example on this, using like the Danish authorities have quite explicitly identified things that would qualify as environmental claims and things that would qualify as claims of sustainability. And using the word green is definitely a gray area, because we all would consider a green, something that's named green, to be kind of a claim of sustainability, but Danish practice quite clearly treats it as an environmental claim. But what happens when we're looking at green bonds, for example, which are one of the primary targets of the taxonomy regulation? Is that then an environmental claim, or is it a claim of sustainability? And there should be a new label specifically relevant to green bonds at some point introduced by the EU, but in terms of other financial instruments or products generally that are called green, it's not clear whether this will be treated as an environmental claim or as a claim of sustainability. Okay, I don't have anything more, so thank you for your time.
Now we are turning to Monika Feigerlová, who is my colleague. She's not only research associate in the Institute of State and Law of the Czech Academy of Sciences, but also a member of our newly launched Climate Center for Climate Law and Sustainability Studies. She's also an attorney at law, focusing not only on international law and transnational cooperation, foreign investment, but also on climate change law. She holds a PhD from Charles University and the master from International Dispute Settlement from Graduate Institute of University of Geneva. She is very active also as a committee member for doctorate thesis in Charles University and member of the IUC and Climate Change Law Specialist Group. Her talk is on climate responsibility under a draft corporate sustainability due diligence directive. The floor is yours, Monika.
Thank you very much, and thank you for the introduction. So once again, good morning or the afternoon to everyone. I would like to add to the piece of the jigsaw by the proposal of the EU on corporate sustainability due diligence directive. So basically, it's still a document in progress. It has not been adopted yet, but it somehow can actually clarify how companies should behave in terms of climate, and in the same way as Emilie mentioned, thereby preventing greenwashing. So in my presentation, I will focus only on some aspects of the proposal. And first we'll speak about climate responsibility, then specifically about climate transition plans, and how this instrument is aligned with the Corporate Sustainability Reporting Directive, which is already a document which is in force and effective. So if we speak about climate responsibility of corporation, it's not a terminus technicus. It is used sometimes in a scholarship, and it's basically an umbrella term for or encompassing various initiatives relating to conduct of companies, and basically includes soft law instruments, emerging regulation, and also market measures. So it is really not a legal term, and it's maybe it's used in a scholarship when we try to somehow understand what are the legal duties for companies relating to climate. As basically business is behind most of greenhouse gas emissions, but the fact is that even at the international level, there is no duty that would mandate businesses to reduce greenhouse gas emissions. So that's why actually the climate change and its negative impacts come to business and human rights agenda, because negative impacts of climate change actually causes violation of human rights, and it has been, I think, more or less accepted universally that it is a human rights issue. So the trend was somehow to derive the obligations of companies through business and human rights soft law instruments that were also mentioned by Emilie, the UNGPs and the OECD guidelines. However, we can see the trend that from voluntary initiatives, we are moving toward mandatory due diligence. It already started 10 years ago with imposing transparency and disclosure regulations. So we, for example, had the non-financial reporting directive. I have to say that today there is clearly a momentous for mandatory due diligence legislation for companies, and the EU proposal is, in my view, the most advanced instrument. But for today, I would like to focus on only one aspect of many of the directive or of the proposal, and actually how this document or how this instrument will help hold companies accountable for their climate commitments. So because if we are trying to establish legal obligation, then we have to speak about civil liability and administrative sanctions. So the two main questions for today are whether the directive imposes something like corporate climate due diligence, and then specifically the climate transition plans that are anticipated to be prepared by companies, whether the plan itself actually can be treated as a binding and enforceable obligation. And for example, civil society or other stakeholders can somehow review the plan, and whether the content is sufficiently ambitious with respect to Paris Agreement temperature goals. I have to say that there is still a lot of uncertainty because, as I said, it's a proposal and it's a work in progress, and we have a number of documents from which I will draw some preliminary conclusions. So first of all, the EU Commission presented its proposal in February 2020. And with respect to this proposal, we already have comments or amendments, both from the European Parliament and also from the member states in the form of the general approach or common position or by the Council. So, lastly, I think 2 weeks ago, the legal committee of the European Parliament actually voted on a report that was prepared by Mrs. Lara Wolters, and it was quite an extensive amendment to both the Commission's and the Council's proposal, and actually, in my view, rectified a lot of ambiguities, and with respect to climate change, at least really strengthened the duties of the companies. And however, in my view, or to my knowledge, I haven't found a document it published. So, as I say again, maybe some of these conclusions will again change because we will have to wait for the text, and it's also not the final text of the Parliament. It should be voted, I think, in June. Another instrument which is important and which are already mentioned is the EU Corporate Sustainability Reporting Directive, which is sometimes called the twin sister of this Sustainability Due Diligence Directive, and very correctly because basically the reporting directive should just regulate the outcome of the procedure, how company assesses its climate risks or the risks of its activities on climate, and publishes the outcome. So basically at first sight, one would kind of assume that the sustainability due diligence directive is the first step, and then the reporting is the second step. However, as regards now the effectiveness and adoption of the documents, we have it backwards. So the main thing from the directive is that actually it contains a separate provision on combating climate change. It's Article 15. So basically that could be a good news that it's on a high-level priority for the Commission and the Council. And if you see here in the article, it says that basically member states shall ensure that companies will adopt a plan that will ensure that the business model and strategy of the company is compatible with the transition to sustainable economy and with limiting the global warming to 1.5 degrees Celsius. That's the entire provision. If we discuss it in more detail, we will find out that actually maybe this provision is totally toothless, and also a major like a step back in my view of the instrument is that it actually deals with the climate aspects of companies' activities outside of human rights and environmental due diligence. So basically the core provisions of this entire directive, which deals with with adverse or with adverse impacts on human rights and environment actually do not cover climate. As I said, there are a lot of documents basically that we can look in how the legislative instrument actually develops. But it's an interesting actually consideration what is in there and how we can eliminate or determine the duties of companies. So the first question is, what is actually the obligation, and then for what the company could be sanctioned. The Commission proposal just said that the company has to adopt a plan, which obviously should not be sufficient, that also the company should effectively implement it or also adopt relating measures in terms of financial and investment plans. And here we can see that there are amendments in these directions, both from the Council and also from the European Parliament, the original report of Lara Wolters. The second issue is that actually what is the aim? Obviously, the aim of the entire directive is to ensure by law that company will transition to sustainable economy and that it will help to limit global warming to 1.5 degrees Celsius. The question is how to achieve that. And for me also the overall question is whether actually we are using the same, the relevant benchmarks. And it has two, I would say, issues or side points. The first thing is that obviously we somehow copy the Paris Agreement goals. But if we realize that Paris Agreement, the addresses of Paris Agreement and of this directive are totally different. And so I would have expected that actually the provisions here in an instrument that should establish a legal obligation upon companies would be more detailed and would be more specific to create legal certainty for the companies. One of the criticisms is also that actually the language or the wording now used suggests that it is obligation of result, that company must actually, its business model must ensure that it's aligned with the limiting of global warming. On the other hand, if we look at Paris Agreement, there is the language of efforts of the states. So we can discuss, to what detail we can go. The main question is also that, as I said, the Corporate Sustainability Reporting Directive actually already somehow deals with climate mitigation plans. And I think the Council here tried to align the language as much as possible with that directive. Otherwise, there is no specific provision which would really link these two documents together. When we look at the Lara Wolters suggestion, I think it rightly points also to the objectives of the EU climate law, which is in my view a correct amendment, and also because obviously the science is also somehow developing, that that transition plan will not be static and should be followed by IPPC recommendations and basically new data. This is I already touched upon. As you can see, when we look at the left-hand column, the first proposal of the Commission is very vague. It really says just that the company should actually assess in the plan to what extent climate change is a risk for the company or its activities have impact on climate. It doesn't actually oblige the company to stipulate a greenhouse gas emission reduction target, which is also something that one would have expected. And this is something which is also contained in the so far proposed, not yet adopted, but standards that were prepared with respect to the reporting directive. Here, the European Parliament's proposal is very detailed, and I think it follows the standards. And as you can see here in red, it anticipates, or the first proposal of the European Parliament was that actually a company should take into account scope 1, to 3 emissions. And what it means is that it's one of the other main issues, that when a company considers its climate strategy, the question is what kind of activities it will consider, meaning whether only the activities, its own activities, for example, if we take the car manufacturer, or whether it also will include the emissions of, for example, the sold cars. So there is a huge difference, obviously, and also the data shows that for most companies, majority of emissions are in scope 3. So, and I understand that there were some discussions in the European Parliament that actually the use of products and services would be excluded. So we will have to see how this will develop and how robust the climate transition plan actually at the end will be. The greenhouse gas emission reduction objective, I have already mentioned it. It's in my view, it's surprising that it's not. It even assumes the directive that actually some companies do not need to set this target. As I say, the coherence with the corporate sustainability reporting directive is a must, in my view. Otherwise, we will lose effectiveness, and also these 2 lines will be very ambiguous. These standards that I mentioned are already available. It's a draft and should be adopted by the Commission, I think, soon. They are called European Sustainability Reporting Standards and contain really standards for the plans. And because I'm aware of the time, I will just mention two final points, which actually relates to, so what is the scope of application and what are the sanctions? So first of all, to what companies this directive applies? It really applies only to very large companies. So it's much smaller number than the scope of companies that need to or are obliged to sustainability reporting under the corporate sustainability reporting directive, which is, I think, estimated for 50,000 companies. Here, this directive, the estimate says that it's about 13,000 companies, EU companies, and 4,000 non-EU companies, but this applies to the whole directive. The Article 15, which deals with the climate transition plan, has actually its own scope of application, which is again smaller. So, and one of the proposals of the EU Parliament was to enlarge the scope. So again, we will have to wait for the developments. And the final point, what I wanted to mention is actually when I said that maybe this provision is a bit toothless, the question is what is actually the sanctions that that company can be exposed to. The directive anticipates that independent supervisory authority will be established, or it can be an existing one in each member state. It should be well sourced, and it will have also investigative powers. The interesting thing is that the council actually amended the original provision of the Commission and suggested that actually the supervisory authority with respect to the climate transition plan will only check if the company adopted a plan, which obviously is not very sufficient, and we may discuss whether actually if a plan qualifies as a plan, that the supervisory authority could actually look into whether it contains some essential elements. But as I say, also the Commission proposal didn't go far enough as regards the details. So this is a bit I think shortcoming of the whole document. The question is, some authors say even that actually this provision, if it will remain as it is under the council proposal, that it doesn't add anything to the corporate sustainability reporting directive, because it depends if we say that that directive already establishes the obligation to prepare a climate mitigation plan, not only to report about the plan. So then we really don't have much here added. On the other hand, the directive, it's it can be shown that, and as Emilie mentioned, that the environment is treated separately from climate change. So actually, as regards directors' duties, it's one of the aspects that actually the directors have to take into account when they the consequences of their decisions also on climate change. As regards civil liability, which is also included in the directive and which will apply to environmental and human rights due diligence, this article so far does not apply to the climate transition plans, but obviously it does not negate any legislation of EU member states that actually have availabilities already, like we have the Shell judgment from Netherlands, so the Dutch legislations which actually enabled this claim that led so far to the first instance judgment will still be possible. Actually, some authors quote the Article 15 of this directive as the Shell norm. So it basically reflects what happened in Shell that should be somehow be possible under Article 15. But as I mentioned, so far the instrument contains several limits. So thank you very much, and I will end here and will look for the discussion.
And now I'm turning to our last speaker. Yes. Thank you. Who is Matteo Fermeglia, who we don't have in this crisis of the FWO. I do not need to introduce, but for other attenders, I would like to say he's an assistant professor at the University of Hasselt for international and European environmental law. He teaches an European environmental law and European climate and energy law. He is also mentoring postdoctoral fellows. In 2017, he was a visiting scholar in the already often mentioned Columbia Law School, where he was also active at the draft in this Sabin Center Climate Change and Law litigation, or started a collection of litigations. He is also working for peer-reviewed journals, and he was awarded with the Rule Estrada Award for Emerging Scholars in Climate Law in 2017. He will be speaking about the EU regulation on carbon removals, chanting muddy waters, so the floor is yours.
Thanks, Rita. Thanks for the kind introduction, which sort of reminded me of the good old days and how much fast time passes. It's good to be here, and thanks to all of you for having me here, and of course for organizing this event within the context of the network that we are trying to steer at Hasselt. I think it's perfectly timely, and also reminded me of a quotation by St. Augustine, which, by the way, you will remember about his concept of time, which is obviously topical for the topic we have today. But he also said once, it is because you pledged that you made me hope. That's a fair quotation, I think, for the topic that we have today, because we are seeing a lot of pledges, and we have been talking about pledges and claims. And I think we have sort of this feeling of belief, that the private sector would take up action against climate change, which is basically upon us, as IPCC has told us once again, and is telling us since the 80s. And I think this touches on the topic that I will try to sort over today as quickly as possible, which I would say is a very Gothic topic. We are in the capital of Gothic, my favorite Gothic city. And looking at how ChatGPT would define Gothic, Gothic would be defined as something that is full of mystery, horror, and gloom. And so when we talk about carbon removal, so this concept of basically soaking up greenhouse gases emissions from the atmosphere, this is a sort of sense that this conveys to me. And I think also the regulatory environment that the EU is trying to set up to regulate this matter, it really much reflects this concept of shadow, of horror, if not gloom. This is why I'm talking about muddy waters, because indeed, to regulate carbon removals when it comes to several issues that we try to flesh out today, it really brings the legislator, but not only the legislator, into the mud. So if you want to go into the mud with me, and if this thing works, I will just tell you how I want to play this. So first of all, I want to talk about carbon removals, what this means very shortly, because it can get us very far. Secondly, I would like to talk about the carbon removals regulation proposal, of course, which is still on the table, still work in progress. So we might see a very different piece of legislation down the line. We might not even see a removals legislation certification at all. We will see about that, but the Commission is quite, let's say, operating towards that end. And of course, going into the mud, trying to understand how, let's say, this proposal has been welcomed so far, especially with regard to greenwashing or climate washing, as you may wish to call it. So first of all, carbon removals. I put here some numbers, okay, to give you the size of the phenomenon, right? Again, as I mentioned, carbon removals must not be conflated necessarily with offsetting. When I talk about carbon removals, I primarily and foremost have in mind really the phenomenon of subtracting, soaking up basically greenhouse gases emissions from the atmosphere, or as they are produced throughout a certain process, which can be, of course, energy generation, if you wish, or it can be also, let's say, waste management. It can take different shapes. So what the numbers out there tell us is that we really need that, right? Let's say it's not a pleasant truth, but this is just what it is. I put some numbers by the International Energy Agency. So these numbers will tell you how much uptake we need of carbon dioxide removal. So literally soaking up greenhouse gases emissions from the atmosphere on the top left, and CCS/CCUS, meaning carbon capture and storage, carbon capture and sequestration, if we want to get to the net zero scenario, meaning playing bingo with regard to the Paris Agreement. And the bottom left side, you have what IPCC tells us. Sorry, I forgot to mention put the source there. So this is also taken from IPCC, let's say, Climate Change for Dummies sort of report, telling us why we need CDR in particular. And it is quite explicitly mentioned that if we really want to go to the 1.5 heaven scenario, we really need to have CDR. We really need to have, we need to upscale techniques for CDR, and we really need to make it now. So these are the numbers out there. And again, whether you like it or not, this is just the reality of things. And if we chart this issue down to the EU context, we have, again, some numbers and charts which can give you the size of the problem or the size of the issue. The bottom picture that I put is a sort of refurbishment by the World Economic Forum of the quite famous chart that you will find in the long-term strategy for climate neutrality by the EU, which actually gives you the sort of leap that the EU collectively should achieve in terms of getting to net zero. So of course, we need to talk about carbon removals. We are not going to focus on the upward side of that chart, but we're looking at the downside. So looking at the negative trend, which is comparably relatively high. And as has been stated in the EU climate law, which, as you know, is a binding regulatory framework for climate action now, we really need to get at least minus 255 megatons of CO2 emissions equivalent by 2030, which again, I remind you, is basically the day after tomorrow, and not referring, of course, the bad movie that we've seen some years ago. So it's really the day after tomorrow. We need to deliver these sort of reductions within the EU, not to mention, of course, the scale of the reduction that we need to get in terms of removals if you want to get net zero or climate neutral by 2050. So to this end, again, to really narrow it down a bit, the issue, what the European Commission did some time ago, quite not under the spotlight, I think, as other initiatives, was the initiative of sustainable carbon cycles. Because, of course, the European Commission recognized that, well, let's say biological carbon cycles are fine, but we also need more of a structured approach to how we deal with certain things, including removals of greenhouse gases emissions. And that's part of the broader framework where, let's say, a regulatory framework conducive for carbon farming, for example, and conducing for, again, carbon removals primarily carbon capture and sequestration would be prompted for by the European Commission. In my eyes, this was quite striking because what I would see reading through the Sustainable Carbon Cycles communication is, well, we need to upscale CCS very fast and very rapidly. And this is quite black and white. And this is quite, let's say, a very harsh and a very prompt message that the European Commission is sending us. And if you think about how many greenwashing claims are being brought by civil society about CCS all across Europe, again, to me, looks a bit, well, unsettling to say the least. So the engine is going, the engine is humming, I would say, literally. As latest developments, which I also wanted to be aware of, is that both the G7 recently really stressed the need to scale up CDR, let's say, activities, including other sidelines like bioenergy with carbon capture and storage, which to me is a very complex and very again gloomy sort of technique whereby you would produce bioenergy and you would basically attach to that go for carbon capture and sequestration directly, as well as, of course, carbon dioxide storage connected to direct capture. So you were talking about a marvelous amount of money, a marvelous amount of technology, and I will add a marvelous amount of energy-intensive techniques that we need to develop. And this is the G7 telling us that we need to do it worldwide. More regionally, the EU, as you know, has put up a sort of response, I would say, to the Inflation Reduction Act in the US. And this is the Green Deal Industrial Plan from the Net Zero Age. And, well, again, the Green Deal Net Zero Age Industrial Plan will say many, many things, but it also has a specific focus on the carbon removals or slash, let's say, well, more generally, carbon removal techniques, including carbon capture and storage, including direct capture, especially in terms of providing simplified regulatory environments, sending price signals, providing faster support to funding, basically, well, to do anything that is in the hands of the market and in the end of the regulator to make this taking off. However, the spearhead of the regulatory responses to this, in this regard, by the Commission is, of course, the certification system. So the best possible idea that the Commission came up with was, well, let's set up a voluntary market for emission removals. So how does this work? Essentially, if you look at to the bottom of to the bottom figure at the slide, which is taken from the fact sheet on carbon removal, so I'm not reinventing the wheel here. So basically, the EU will develop some methodologies to certify carbon emissions and removals, and we will see about that. Operators will join the certification scheme. Everybody would be happy to join the certification scheme, of course, because the criteria would be super transparent and would be super stringent in terms of how we verify, of course, carbon removals. Then there will be a third-party verification. Nobody is really aware of what this third-party verification process would look like. But nonetheless, at some point, the different carbon removals activities will be certified eventually. So you will get your own piece of paper that you will be used basically to leverage private funding, public funding, or you can use it in a proper voluntary market. This should be then put in a registry, of course, for the sake of transparency, so everybody will be able to, you know, check up on you, perhaps bring you to court. We will see about that. It's not completely clear either. Being that said, what are the criteria according to which, let's say, the certification scheme will work? And here, I would say that the European Commission, as always, has been quite creative and quite, you know, quite fancy in terms of finding, in terms of marketing, because they are talking about quality, right? And if you look at the acronyms there, it stands for quantification, additionality, long-term storage, and sustainability. Again, I'm not providing answers perhaps today, but I just want to prompt in your minds what is the approach towards carbon removals here. So a carbon removal to be certified and therefore to enter this voluntary market scheme to provide some sort of economic incentive and to spark some sort of scalability of these activities should, first of all, provide measurable, let's say, and carefully accounted for benefits. This, of course, speaks to the need to provide baselines to understand exactly what these quantifiable removals are measured against. And that comes the second point, which is related to additionality. Additionality, in the Commission words, means that activities must go beyond standard practices and also what is legally required. And so if I think about the legal bonds that are now put on private entities, I wonder what legally required would mean. What would be benchmark there? Anyway, the third point, which is even the more contested so far, is the long-term storage context. So carbon emission removals will only be certified as long as they require and they ensure long-term storage, meaning that the CO2 or whatever greenhouse gas that is captured must be removed for a certain amount of time, which is supposed to be long-term. And this is the key issue around the whole certification scheme, to distinguish between permanent and short-term removals. And fourth point is sustainability, of course, which is sort of obvious in a way, meaning that, well, while you're doing carbon removals, you should not screw up the environment, right? So you should not come at the detriment of other priorities such as biodiversity protection, adaptation, water resources, and so on. Why? Well, because as I understand it, most of the techniques that are going to develop carbon removals are, again, resource and energy intensive, extremely resource and energy intensive. So in the idea of the Commission, the ideal world would be activities that make everybody happy again, and that hopefully do not harm the environment in the end, down the line. So how has this proposal been welcomed or not welcomed, I would say so far? In the words of the Commission, which I put at the top of this slide, recital number 4 of the proposal, the certification framework will support the development of activities in carbon removals, which should result in an ambiguous net carbon removal benefit while avoiding greenwashing. Ideal world by far. Is this really happening? Is this really what, let's say, at the moment, the industry as well as NGOs are really seeing as happening under this certification scheme? Not necessarily. So 8 NGOs have already filed a letter to the European Commission saying, well, look, this proposal is basically immature. It does not, let's say, align with the European targets and international targets. It is basically operating self-standingly. So it is a sort of new, free field for cooperation to explore. And of course, it pursues the message that offsetting or, let's say, going for carbon removals is the best way to go and sends economic incentives there too, which is, of course, related to the potential chilling effect, I think that Elias mentioned before in this morning. These are just some of the criticisms that have been raised. Funnily enough, this proposal didn't make industry happy either. So the CCS industry has joined the voice of NGOs, and this is a sort of quite an achievement by the Commission, I think, here, to put CCS industries and NGOs on the same page here, criticizing the proposal, well, because it basically doesn't really strike a fair balance between short-term and long-term carbon removals again. So basically putting on the same footing, for example, carbon farming activities, reforestation, and CCS. And CCS people will tell you, well, this is not fair because we are storing CO2 basically for potentially 100 years, while I'm sorry, if you just do reforestation and you get a wildfire, well, all the CO2 will be basically released back in the air. And you can make a market out of it. You can make an economic business out of this, right? And you can make also environmental claims out of this that would increase your reputation and might distort the market. So again, I'm not putting any solution here. I've been speaking too much. I just, in a minute, sort over the most important points here, which are some of them already mentioned. Again, the key issues and the key points where also greenwashing or climate washing might arise in the context of carbon removal certification is first, what is a permanent and what is a temporary storage for the purpose of the certification? Is this quantifiable in terms of time frame? Is this quantifiable based on activities? This has to be seen. What is additionality? Meaning what is the baseline against which we quantify the additional removals gained by a certain activity? Thirdly, of course, the monitoring and reporting, especially for carbon farming activities, which can be wide-ranging. How do we monitor? How do we verify the emissions there? And how do we report back? Baselines, again, boils down to the additionality issue. Baselines now are mostly referred to under the existing protocols, like the GHG protocol, for example, internationally, or ISO. But I think the Commission is going to go beyond that. Then, of course, responsibility. Who is responsible if CO2 is being put back into the atmosphere? If the CCS storage site blows up, if a brand new forest catches fire, and so on. This is not completely clear in the proposal. And then 2 points that are quite interesting to me, the social safeguards. For example, how do we account indeed for certain dynamics that can be spurred by carbon removals, for example, bioenergy for carbon capture and storage, including land grabbing outside the EU or even within the EU? This is a big question mark that NGOs have flagged. And last, the systemic interaction within the jigsaw, right? So this carbon removal, again, is a self-standing proposal. How does it interact with the ETS? Not much in the eyes of the Commission. How does it interact with LULUCF? It should, because it should contribute to the LULUCF targets. But of course, we have crisscrossings there that are already being challenged before courts of law in terms of accounting, in terms of transparency. Last point, this is out of this bucket list. How does public participation, access to information play into this picture? This is a question that is not being addressed by the Commission. The Commission says, well, the Aarhus Convention can be applicable, but to me, it's not completely clear how we can actually provide teeth to public civil society to, let's say, attack potential false claims or, let's say, misleading claims under this framework. But again, there is more to that. I see there is already 2 p.m. So thanks for everybody for listening, and hopefully we can have a discussion afterwards now. Thanks.
Thank you very much. Thank you for this very great panel. Thank you for your attention. Thank you for the remarks and also for the questions. I think we will elaborate them in our future research. And I believe that in frame of FWO or on another platform, we will have the opportunity to debate on also in the future. Thank you very much.